My name is Diane Dreyer. I'm the Vice President of the Gas Drilling Awareness Coalition of Luzerne County. About 5 years ago, a handful of citizens from the Back Mountain area of northeastern Pennsylvania became concerned about unconventional gas wells that were scheduled to be drilled in their communities. Gas industry representatives were holding informational meetings for elected officials and residents in affected communities. Many residents came away from those meetings with grave concerns about the effects of unconventional gas drilling on the environment and on public health. Those concerned citizens formed the Gas Drilling Awareness Coalition, known as GDAC, whose mission is to educate the public about the negative environmental consequences of natural gas extraction, processing, and transportation. GDAC, at all times, conducts itself in a lawful and peaceful manner, with members using their First Amendment rights to provide educational information to the public. That's why it was so surprising to learn that in 2010, GDAC was mentioned in several intelligence bulletins issued by the Institute of Terrorism, Research and Response, an Israeli-American security firm, under contract to the Pennsylvania Emergency Management Agency's Office of Homeland Security. As Philly.com reported on September 22, 2010, the bulletins came to light after Powers, who is the former director of Pennsylvania Homeland Security, mistakenly sent a woman opposed to natural gas drilling an email that said he wanted to, quote, continue providing support to the Marcellus Shale Formation natural gas stakeholders while not feeding those groups fomenting dissent against drillers, unquote. According to a report in Penn Live on November 7, 2010, regular readers of the bulletins could easily begin to view activists as a threat. The bulletins freely mixed references to actual terrorist activity abroad with warnings about the nonviolent, lawful activities of Pennsylvania citizens. Then Governor Rendell apologized to the groups that were mentioned in the bulletins, saying that he was deeply embarrassed and canceled the state's contract with the Institute. According to published reports at the time, Rendell said that the information was useless to law enforcement agencies and that distributing it was tantamount to trampling on constitutional rights. We agree with former Governor Rendell that this conduct by the Pennsylvania state government was tantamount to trampling on our constitutional rights. We believe that collecting and disseminating information about groups that are engaged in lawful activities, and especially labeling those groups as potential terrorists, can and does have a chilling effect upon the freedom of speech guaranteed by the First Amendment to the Constitution that we all hold so sacred. That is the reason that the Gas Drilling Awareness Coalition decided to file this lawsuit in December of 2011. I will now defer to our attorney, Paul Rossi, for further explanation.
Thank you. Good afternoon. Thank you for being here. My name is Paul Rossi, R-O-S-S-I. I am the attorney for Gas Drilling Awareness Coalition. We are here today to announce and celebrate a major victory in the continuing fight to secure First Amendment rights in the post-9/11 world. A federal judge in Pennsylvania has reaffirmed for the first time since the terrorist attacks of 9/11 that Cold War-era case law prohibiting government officials from publishing derogatory commentary on public speech to non-governmental third parties implicates an impermissible chill on guaranteed First Amendment rights. In his opinion, Judge Caldwell also ruled that the First Amendment protection against government officials from casting public aspersion on First Amendment speech is so well and so clearly established in the case law that government officials who ignore this aspect of the First Amendment will be subject to personal financial liability for violating our right to engage in speech free from governmental interference. In addition to Judge Caldwell's clear ruling in favor of the First Amendment, the Commonwealth of Pennsylvania, and I believe you have a copy of the letter, has finally published a letter admitting that the Commonwealth was never in possession of any information which warranted placing my client on what amounted to a tri-weekly terror watch list. Specifically, Director Clannon, on behalf of the Commonwealth, certifies that the information contained in the Pennsylvania intelligence bulletins about GDAC, quote, was unreliable and incorrect. Director Cannon further states that, as director of PEMA, I can state unequivocally, and I assure the public, that this agency has no information or reason to believe that GDAC at any time in the past or currently could be fairly characterized as a terrorist organization, as the Office of Homeland Security and ITAR stated or implied in the material that they distributed in 2010. Perhaps most importantly, Director Cannon goes on and asserts that PEMA has no reason to doubt GDAC's representations, that it has done nothing more than engage in the exercise of its rights guaranteed under the constitutions of the United States and Pennsylvania. While our litigation against state officials has successfully concluded, we intend to continue our litigation against Mr. Perlman and his shadowy ITAR operation, who we believe is most responsible for concocting the blatant, intentional, and unfounded lies contained in the Pennsylvania intelligence bulletins, lies which were targeted not just at GDAC, but dozens of other peaceful political and educational organizations in Pennsylvania who simply espouse viewpoints that Mr. Perlman personally disagreed with. All so they could bilk Pennsylvania taxpayers to the tune of over $100,000. I'll answer any questions you guys may have at this point.
So, beyond this letter, were there settlement terms? First of all, was this letter part of the settlement?
The letter allowed us to enter into a settlement. The letter came first, and then we entered into a settlement. The terms of the settlement are confidential per the Commonwealth's demands.
So the terms of the settlement with the Commonwealth
are... They're confidential. I can only let you know that we have settled the case. I can't talk about that.
This letter.
The letter essentially establishes that they never had any information concerning my client which warranted putting them on the list, and that the list and those Pennsylvania intelligence bulletins were essentially made up whole cloth by ITAR and Perlman. And that essentially clears the name. Remember, these bulletins went to all law enforcement and also private parties. So we're sending this letter to everyone who received these letters to clear GDAC's names. This letter, this admission by the Commonwealth, allowed us then to enter into further settlement terms which are confidential.
What about Perlman and, say, ITAR?
Well, Judge Caldwell dismissed the case against him. In the first instance, he said they weren't. Constitution only applies to state actors, right, to the government. He said that he was not a state actor in this limited situation. We disagree with that. We're going to appeal that to the Third Circuit. We also had defamation claims which were dismissed, but this letter is going to be used as evidence that everything he put in the intelligence bulletins about GDAC were false. So this letter also provides further evidence in this court case against Perlman. We're going to go back to Judge Caldwell and respectfully ask him to allow us to amend the complaint to include these allegations which conclusively show that he simply lied about my group, and that clearly states a defamation claim that ought to be litigated as a pendent state law claim in the federal court. Then we're going to go to the Third Circuit and have the Third Circuit overturn his decision on state action. We are going after Perlman.
Again, do you know what the value of the contract is?
$100,000, over $100,000 if I recall. It was at least $100,000. It may be a little bit more than that.
I'll be a pest again.
Sure, no, please do. That's what we're here for.
There was references in letters from Deputy Attorney General Rossi, injunctive relief and attorney's fees. So,
I simply can't comment on it. If I comment on it, it'll be a breach of the agreement. Sorry.
the claims against Perlman and Itar, defamation?
Defamation and constitutional violation. We believe anybody who steps into the shoes of the Pennsylvania State Police to collect information and to warn the Commonwealth about potential terrorist threats, that is an essential state function. Judge Caldwell sort of characterized it, well, he's just a contractor collecting information. Well, he did more than that. That's like calling private prison guards just, private security firms doing private security work. When you supplant the state police's intelligence unit with a no-bid contract where you alone are determining who is going to be reported as terrorists, we believe that's state action, and we're going to take that to the Third Circuit if necessary. But on the defamation claim, this is brand new evidence that Perlman never had any information to suggest or properly place my clients on that list.
Does this the start of clearing your name, gaining your reputation back?
Well, I think most people probably understand that after all the media attention that these reports were bogus from the beginning. But nevertheless, it's nice to have the Commonwealth reaffirm that there's nothing lurking in their files that might actually implicate them in anything. So this was a necessary letter in order for us to even begin to discuss settlement.
You reiterated and stressed that what you were doing was lawful and
correct.
At no time.
This is an educational organization. There's no reason for them to be. Look, Perlman doesn't like environmental groups. That's why they were on these lists. Period. He's in the pocket of the gas companies. He still is, we believe, and this is just his modus operandi.
Is he still working in bulletins?
I'm not going to comment on that. We've been keeping tabs on him. Just let me drop it on.
Did he have the other groups named?
GDAC's the only one that came forward to. Yeah, I mean, there's a whole list of potential plaintiffs that were out there. They never filed an action. One of the major rulings here is that qualified immunity does not apply in this case. The judge said this case was such a clear violation of First Amendment rights. Any state official that does this or does this in the future, they're going to be liable personally for economic damages to the, and that's usually not the case. Usually in constitutional cases, you can only get prospective equitable relief, like declaratory relief or injunctive relief. Here, the judge said you can go after them for money damages. So in the future, state officials better be darn careful not to take this opinion to heart and not violate the First Amendment. You look like you.
Were the state officials, they were dismissed from the suit?
No, they were not. Perlman and Itar were. State officials are still in. That's why we were able to settle.
You were suing them in their official capacity as well as personally?
In their official capacity. Only their official capacity. And even in their official capacity, they didn't have immunity because what they did was so clearly a violation of the First Amendment. Judge Caldwell denied them qualified immunity in the lawsuit, which, quite frankly, is probably why we reached the settlement, because they understood that they were in deep trouble, I think.
When did he make that decision?
That was in December of 2012. It's taken this long to get them to get this letter to us. There were extenuating circumstances on opposing counsels. I don't want to cast any aspersion on opposing counsel. It just took this long for various reasons to get to an agreement on all terms.
So, because the agreement is confidential, can I take that to mean that no public monies are?
I can't comment on it.
Involved here?
I can't comment on anything.
Because if there's expenditure of public dollars, you'd think that would be.
Well, you guys are free to do any kind of snooping around you want to, but we cannot comment on the terms of the settlement. Sorry. I'd like to, but I can't. I think you guys in the media understand that the Commonwealth, whenever they enter into a settlement, always demand that it be confidential. It's just the standard operating procedure. Sorry. I tried not to, but it is what it is. I'm sorry, what?
These are both in
Middle District, Judge Caldwell, who did a fantastic job in this case. We disagree respectfully on some points, but this was such a clear case that frankly, it should have never happened. And to the extent that it's still happening, we're researching new fact patterns, that this stuff is still going on in different parts of the government, and you may be seeing something in the future on this. But this has to stop. State officials ought to read these media reports and understand they can't do this in any form whatsoever.